Taylor Swift crushes plagiarism lawsuit as judge delivers crushing blow to copyright claim. Swift wins big as federal judge throws out plagiarism lawsuit. Taylor Swift has defeated another plagiarism lawsuit, and the decision matters far beyond one celebrity courtroom fight. A federal judge dismissed the case brought by Florida poet Kimberly Marasco, who alleged that Swift had copied phrases, themes, and imagery from her poetry across more than a dozen songs. The ruling is a major win for Swift, because it does not merely end one complaint. It reinforces a principle that protects songwriters, poets, authors, and artists from having ordinary language, emotional themes, and common metaphors treated as private property. The case was dismissed with prejudice, meaning Marasco cannot keep amending the same complaint in that court. What happened? Marasco accused Swift of using material from her poetry in songs including Down Bad and I Can Do It With a Broken Heart, both from Swift's 2024 album The Tortured Poets Department. The lawsuit also named other music industry defendants, including Republic Records and Universal Music Group, according to reporting on the court decision. U.S. District Judge Aileen Cannon rejected the claim. The court found that the alleged overlaps were not protectable expression, but instead involved broad ideas, familiar themes, metaphors, and isolated words. That distinction is central to copyright law. An artist can protect the specific expression of a creative work, but not every ordinary word, mood, trope, or emotional situation that appears in it. This is why the ruling is so important. Swift was not cleared on a technicality alone. The court's reasoning went to the core of the accusation and found that Marasco had not plausibly shown the kind of protectable copying copyright law requires. Why the court's reasoning matters. Copyright law cannot function if common emotional language becomes locked away. Love, grief, betrayal, rain, heartbreak, gaslighting, survival, drowning, pain, and recovery are not rare human experiences. They are the raw materials of art. The U.S. Copyright Office makes the same broad point in its public guidance. Copyright does not protect names, titles, slogans, or short phrases, and copyright does not protect ideas, concepts, or principles. It protects the creative expression fixed in a work, not the underlying emotional territory that other writers may also explore. That distinction is especially vital in pop music. Pop lyrics often work because they compress huge emotional states into direct, repeatable language. If courts allowed lawsuits to proceed every time two writers used similar fragments about heartbreak, darkness, tears, storms, or survival, the result would not be more creativity. It would be legal paralysis. Swift's win, therefore, protects more than Swift. It protects the basic freedom of artists to write about shared human experiences without being accused of theft every time someone else has written about the same feeling. The history behind the case. This lawsuit sits inside a longer pattern of copyright claims against Swift. Her most famous earlier battle involved Shake It Off, after songwriters Sean Hall and Nathan Butler alleged that the song copied phrases from 3LW's Playas Gun Play. That case was filed in 2017, dismissed in 2018, later revived, and then dropped with prejudice in December 2022 before a scheduled trial. That earlier case became a flashpoint because it raised the same basic question: can short, familiar phrases become the basis for a major copyright claim? Swift denied copying and argued that the phrases at issue were common cultural expressions rather than protectable creative property. The eventual dismissal ended that dispute, but the wider issue did not disappear. The Marasco case brought the question back in a different form. Instead of one hit single, the allegations stretched across multiple songs and albums. But the court again focused on the same legal filter: whether the plaintiff had identified original protectable expression and whether Swift's work was substantially similar to it. Timeline. The wider timeline begins in 2014, when Shake It Off was released and became one of Swift's defining pop records. In 2017, Hall and Butler filed their lawsuit over alleged lyrical similarities. In 2018, the case was dismissed, before later being revived on appeal. In December 2022, that dispute was dropped with prejudice before trial. In 2024, Swift released The Tortured Poets Department, an album that became part of Marasco's later claim. In February 2025, Marasco filed the federal complaint against Swift and other defendants. In 2025, an earlier version of the claim was dismissed, and on July 6, 2026, the court dismissed the amended case with prejudice. That final point matters most. A dismissal without prejudice can leave the door open for another amended complaint. A dismissal with prejudice is much stronger. It signals that the court saw no viable path for the claim to be repaired in its current form. Why this is a strong win for Taylor Swift. The pro-Swift reading is straightforward. The court accepted the basic argument that the claim tried to stretch copyright beyond its proper limits. Swift's work is built on personal narrative, emotional precision, and the transformation of common feelings into commercially powerful songs. That does not mean every word connected to heartbreak, resilience, or pain can be treated as stolen. The ruling also cuts against a recurring celebrity problem. Famous artists become large targets because their work is visible, profitable, and easy to compare against almost anything. Once an artist has hundreds of songs in public circulation, it becomes easier for a claimant to find scattered words, moods, or images that appear to resemble their own writing. But resemblance is not enough. Copyright does not exist to punish coincidence, shared language, or common experience. A plaintiff must show protectable expression and legally meaningful similarity. In this case, the court found that burden had not been met. The significance for music and culture. This decision lands at a tense moment for the music industry. Artists are already navigating pressure from streaming economics, fan scrutiny, ownership disputes, and the rise of generative AI. Copyright is becoming more important, not less, but that makes legal boundaries even more necessary. A world with weak copyright would harm artists, but a world where ordinary phrases, themes, and emotional metaphors can be monopolized would also harm artists. The balance is difficult, but the Swift ruling pushes back against the idea that broad emotional overlap should be enough to drag a songwriter into prolonged litigation. That is a healthy result. Creativity depends on influence, shared language, and recurring human themes. The law should punish real copying. It should not turn every sad song, breakup line, or metaphor about drowning into a potential lawsuit. The implications. Now, for Swift, the immediate implication is legal relief. The case has been dismissed with prejudice, and although Marasco has indicated she disagrees with the decision and intends to appeal, the district court ruling is a decisive defeat for the claim as pleaded. For other artists, the implication is wider. The decision strengthens the argument that copyright claims must identify concrete protectable expression, not simply a cloud of similar feelings, themes, or fragments. That matters in music, poetry, publishing, and digital culture, where vast bodies of work can now be searched, compared, and accused at speed. For Swift's public image, it is another example of her legal operation, holding the line. She has spent years being accused, analyzed, and challenged at a scale few artists experience. This ruling gives her a clean answer. The court did not find plagiarism. It found unprotectable ideas, common language, and no substantial similarity strong enough to sustain the lawsuit. The bigger story is therefore not just that Taylor Swift won. It is that the court refused to let copyright become a weapon against the ordinary vocabulary of emotion. That is good for Swift, good for songwriters, and good for anyone who believes artists should be free to write about heartbreak without first checking whether someone else has already used the rein.